We are going to start. The topic is demystifying the conundrums of subclassification in scheduled caste. Recent constitution bench judgment, 7 judges. Speaker is our beloved Devashish Bharuka, senior advocate, and earlier also he addressed on 25th November 2022 employees pension, last minute catch that time also, and again 9th February 24 Indian Constitution, his own book. Today 11th hour I catched him, he ready to discuss this thing. Actually this is the judgment of state of Punjab versus Balbir Singh, Devendra Singh. So that's very interesting that entire India is waiting, and yesterday, day before yesterday, they declared strike also on the judgment. Now Bharuka ji, please you can.
Thank you, sir. Thank you, everyone. Good afternoon. It's always a pleasure to come back to this group and exchange ideas and thoughts, and in the process learn. Since this is all part of continued education, and education connects with, a lack of education connects with backwardness, and that is what the topic is today, about the backward citizens, the classes of the country. Now we are today here to discuss the 7 judges' judgment of the Supreme Court in state of Punjab versus Devendra Singh. That, and in very short, what it really holds, it's a bench of 7 judges, 6 judgments in the majority, and a dissenting judgment. I'll be discussing each of those judgments separately. But ultimately, what they really hold is that sub-classification is permissible within the scheduled caste for the purposes of reservation. That was something which was earlier by another 5 judges was held to be impermissible. So that judgment has been overruled. I'll discuss that, both the judgments, and then the reference judgment of other 5 judges of Justice Arun Mishra, and thereafter finally the 7 judges judgment. So just before that, a bit of probably a historical perspective of this system itself, and why I'm keen to look into that historical perspective is that one of the judges, Justice Pankaj Mittal, discusses on the Varna system of ancient India, where he says that historically, to his understanding, there was no caste system in India at all. In the ancient India, which we know as Bharat, which is also part of Article 1, India, that is Bharat. So in those ancient Indian times, there was no caste system as per Justice Pankaj Mittal. And he looks into the Varna system, where profession-based division of the society was made, and it was not really looked upon or looked down that one is having a higher profession or lower profession. It was more a profession-based system which continued at that point of time. And from there onwards, 1500 BC around, when we had the Aryans coming in, and who really, the historians say, bring in the caste system, and that's where we had the 4 caste system, from Brahmins to Kshatriyas, and then down to the downtrodden, called the Shudras. So that is probably where the caste system starts taking some kind of a rigidity in the Indian system, to the extent that not only it was a caste system, that with that caste system one started seeing a bit of social disablements across. There were certain social restrictions which started coming out with that system, and that is where one realized that there were these problems within the society which required some kind of a rectification. Today what we are really concerned with in these judgments is about the public employment. Now, over the years, as we moved ahead and the Britishers came, this caste system became a completely fixed part. They also realized that this is something which would help them in terms of divide and rule. And yet, over time, as we had more of social movements coming in, maybe in the late 1800s, early 1900s, this system was seen as a menace for the society, and especially for the purposes of upliftment of the lower strata, for the purposes of public employment. That's an area which is what we are really concerned with today. But because of this hierarchical system, public employment or involvement in the state machinery was something which was impermissible for this lower strata of the society. Those areas were where which required reforms, pre-independence, I believe there were some of the princely states, like some in Kerala, a bit of Mysore, Madras, Bombay, which over time started creating some kind of a reservation areas for the lower strata, for what they called at that point of time the depressed classes. So for the purposes of depressed classes, some of the princely states did offer certain areas of public employment. 1935 Act probably is the first one where there was some kind of a reservation for the purposes of scheduled caste. That's why the scheduled caste was used for the first time. Then as we move forward towards the Indian independence, after the independence, when the Constituent Assembly sat for the purposes of setting up the Constitution, then in the draft Constitution, the Article 16 today for public employment was the draft Article 10. Interestingly, when the first time the draft Constitution was approved by the Assembly, the word backward was not there in that draft Article 10, which was Article 16 eventually. Later on, the drafting committee inserted the word backward, realizing that it is truly that this entire special provisions, especially in public employment, must be for the purposes of backward classes of India. Because it is those classes which Dr. Ambedkar said were deprived of the real benefit of being a part of the state machinery, of the state governance. They were deprived of not being able to look into how the administration works. And that is where that upliftment would be required, as opposed to what they had been doing otherwise. So it was in draft Article 10 that the word backward classes was inserted, and then that was ultimately approved by the Constituent Assembly. One area which probably what Justice Gavini's judgment has noticed is one of the most important events is at a later stage, Dr. Ambedkar introduced Article 300A, capital A, and Article 300, capital B, the draft articles which eventually is adopted as Article 341 and 342. Now 341 and 342, particularly 341 is what we are concerned with today, is where the President would be passing an order upon consultation with the Governor and identification, a list of scheduled castes. So what is the import of Article 341? Because 341 says that whoever those castes or subcastes or groups which are part of 341 list of the President are deemed to be scheduled castes. So there was some kind of an identification given to certain castes and groups depending upon the empirical data where they were declared to be scheduled caste. The interpretation of Article 341, which Justice Gavai says is one of the most important events in his judgment, that came up for consideration in his judgment. We'll look into it as we move forward. But 341 and 342 is something which is extremely important. Of course, Dr. Ambedkar said that I am wanting to have this list out of the Constitution itself because it will otherwise overburden the text of the Constitution. It is better that the President at the first go makes a list. The Parliament then would have the right to include or exclude castes into that list, but not the state governments. So that is 314 and 342. Post-independence, there were two specific backward class commissions which was formed. One was as early as in 1953, a report was made but eventually rejected by the central government. Thereafter came the famous Mandal Commission report. Mandal Commission report, as we all know, led to a 27% reservation, which was eventually upheld by the Indira Sawhney judgment. But these were the two commissions at that point of time which are substantial for our consideration. Now, before I really move on with the main judgment, there is another area probably which will be of interest, and that is a slight journey of how the reservation itself progressed right post-independence in terms of constitutional amendments and the judgments of the Supreme Court. And as we shall see, at the end of the day, both were really going hand in hand. So initial years, the Supreme Court felt that certain areas, because of equality, would not permit a reservation of that kind. So at first of the judgment was Champak Dorai Rajan. The Supreme Court refused to have a caste-based reservation for admission in medical colleges. That led to the First Amendment, an insertion of clause 4 in Article 15. That was the first part of the journey towards having an equality clause to uplift the downtrodden of the society. The second one was in respect of insertion of Article 16(4) capital A for the purposes of promotions. That's the 77th Amendment of the Constitution in 1995. Thereafter, those also related to 3 or 4 more amendments, but all of them were eventually upheld by the Supreme Court in M. Nagaraj. A very interesting judgment came about in S. Vinod Kumar in Supreme Court, where it says that if you are lowering the qualifying marks for the purposes of SC, ST or OBC, that is not permissible, because that's something which is not within the realm of the Constitution. That led to another amendment, that was the 82nd Amendment, where under Article 335 a proviso was inserted, so that the marks for the purposes of qualification can be lowered under certain circumstances. So that was another round of changes which happened in furtherance to the reservation policy. Another one which is with respect to Article 15, Clause 5, which inserted for the purposes of reservation SCBC, SC, ST and educational institutions. That was in 2006, 93rd Amendment, that was upheld in Ashok Kumar. And then the 103rd Amendment was with respect to economically weaker society sections, which was upheld in Janhit Abhiyan by Supreme Court in 2023. So that's like a little journey of how things progress really in terms of reservation within our constitutional system. Now coming back to in view of this background, coming to now the main issue. The 5 judges bench of Supreme Court in E.V. Chinnaiah initially held, and that is where the Supreme Court came up with an act of Andhra Pradesh legislature, which actually picked up the caste laid down by the president under Article 341, and then it categorized into 4 groups and divided the reservation into those 4 groups. So in a way, it subclassified the already classified list of scheduled castes which was in the president's list. That is what came to be challenged, saying this is impermissible within the 4 corners of the constitution, because once a list is made by the president, it cannot be tinkered with by the state legislature. As you'll all recall, so far as the article is concerned, Article 241 provides that the president makes the list first, and then after, only the parliament can add or subtract out of that list. So the argument was that the moment you try to subclassify within that list being a homogeneous in character, the moment you try to subclassify, that will actually amount to tinkering with the president's list, which the state legislature has no power to do. There's a very interesting argument by Mr. K.K. Venugopal in that matter, who was appearing for the state. So there were 3 judgments in that matter: Justice Hegade's judgment, Justice Sema and Justice Isbison. I'll quickly deal with all those 3. But Mr. K.K. Venugopal was appearing for the state. He argued, and I would say exactly what now 7 judges bench has held. So what he argued that Article 341 only empowers the president to specify the caste in the presidential list, but beyond that, no further legislative executive power is vested with union or parliament, and it is the exclusive privilege of the state to assess as to what the quantum of reservation would be. So his argument was that you have the list, I am not tinkering with that list, but how exactly I will be offering reservation within that list is really the prerogative of the state. As we know, ultimately Justice Hegde said that no, the state has got no power for the purposes even to do that subclassification. Justice Hegde's judgment was quite clear. Article 241, number 1, provides for redeeming fiction. So let me just read 241 for better understanding. 341. So what it says is the president may, with respect to any state or union territory, and where it is a state, after consultation with governor, by public notification, specify the caste, race or tribes or parts or groups within caste, race or tribes, which shall for the purposes of this constitution be deemed to be a scheduled caste in relation to that state or territory. So the word deemed, now normally we all know that the word deemed, whenever it's used, it amounts to a legal fiction. And a legal fiction is something that maybe this is not the real situation, but then by way of law, a fiction is created that this is how a certain things has to be treated in a certain manner. Now the word deemed is where the judges picked up to say, that's the Chinnaiah judgment, Justice Hegde. He says the moment there is a word deemed, it is a legal fiction, and therefore for the purposes of the constitution, these castes will be treated as scheduled castes. The moment they are treated as scheduled castes, they are now a single unit, a single homogeneous unit, which cannot be now further subbroken or subclassified. If you have to give benefit, you give benefit to the group as a whole, or you don't give benefit to it. So that is what Justice Hegde's ultimate understanding was, and he says therefore state has got no power in terms of subclassifying. Another thing which was pointed out, and I think Indra Sawhney's judgment came about heavily while he discussed this. Indra Sawhney judgment had held that subclassification is permissible for other backward classes. That is a specific finding in Indra Sawhney. However, Indra Sawhney also said that whatever we are saying is not really applicable to SC/ST. It says that we are excluding, we are not really discussing about SC/ST, we are talking about OBCs because Mandal Commission was really about that. So in that situation, SC/ST is not applicable. So Justice Hegde picked that up to say that Indira Sawhney, though specifically permits sub-classification for OBCs, it does not provide for SC/ST because it excludes those. And therefore that's another reason as to why it should not be permitted. So that was Justice Hegde. Justice Sema gave a concurring opinion. He also gave his own purpose and object of Article 341. He says it's all a single class, single entity, a single homogeneous group, and therefore it cannot be that you can subdivide. Justice S.B. Sinha, that was the third judgment in this 5 judges judgment, he again looked into issues of reservation, determination, etc. And finally he also went on the same lines, concurred with the other 2 judges, Justice Hegde and Justice Sema. And he also said that so far as 341 article list is concerned, that is something which is single, it is a homogeneous unit, and the state government cannot tinker, it cannot subdivide, it cannot subclassify, and therefore the Andhra Pradesh Act was struck down. So that was the E.V. Chinnaiah judgment. Now it so happened that subsequently there were 2 or 3 states who, despite this judgment came up, they realized that there is, and this was all actually based on factual analysis and empirical data, that they realized that within the SC, the scheduled caste list itself, there are people who have reached a certain higher level as opposed to a whole bunch who have not. And therefore it is necessary to give further affirmative action means or measures for those who are at the lower level of even that SC list. And therefore in that situation, Punjab came up with an act where it provided for some kind of a sub-classification, especially a preferential treatment for 2 of its specific castes within the scheduled caste list. That came to be challenged eventually in Supreme Court. And the Supreme Court, this is State of Punjab versus Devendra Singh, 2 judges bench referred it to 3 judges, believing that the earlier judgment of Chinnaiah is incorrect. And 3 judges went to 5 judges. Now 5 judges judgment is written by Justice Arun Mishra. It is a very, very detailed judgment. So it's a reference order. But after the reference history, etc., it looked into everybody's arguments. And what they discussed was, number 1, it looked into Indira Sawhney's judgment, especially Justice B.P. Jeevan Reddy's judgment and Justice P.B. Savar's judgment. And it took note of the fact that on one hand, Indira Sawhney judgment does say that such classification is permissible within OBCs. Then it notes that it is not that SC/STs are completely excluded of this principle. The reason was SC/STs are already identified backward classes by way of the presidential list. And therefore to say that Indira Sawhney completely excluded the applicability of subclassification would be an incorrect reading of Indira Sawhney. So that was first point which Justice Arun Mishra took note of, that Indira Sawhney could be in some manner actually helping in what we are trying to say, subclassification. Second, he notes that caste itself is a social class in the context of the constitution. Historically, caste would have a different connotation, but for the purposes of Article 16.4, if you remember what we said, backward classes. So ultimately all of them merges into classes. Here at this stage, let me also now read the definition of caste in Article 366, Clause 24. Scheduled caste means such castes, races or tribes or parts of or groups within such castes, races or tribes as are deemed under Article 341 to be scheduled caste for the purposes of this constitution. So the word scheduled caste itself has now a definition in the constitution, and it again connects it with Article 341, the deeming fiction, the legal fiction, that those which are part of that list will be deemed to be scheduled caste for the purposes of this constitution. Now, if you remember, this deeming fiction is what eventually had led Justice Hegde and Justice Sinha and Justice Sema and E.V. Chinnaiah to hold that because it is a deeming fiction and therefore it is a single homogeneous unit. We will see how that was eventually read into, particularly by Chief Justice Chandrachud in the Devendra judgment. But this reference order, in the meanwhile, as you were looking, it says caste is a social class. Then it looked into again Indira Sawhney for the purposes of preferential treatment and held that even preferential treatment Indira Sawhney holds permits for the purposes of OBCs, that is the other backward classes. And if that be so, there is no logical reason as it should not apply to SC/ST as well. So these are the reasons which were pegged up by Justice Arun Mishra in the reference judgment. We eventually hold that we need to actually refer it across to a larger bench for reconsideration. Another area which was looked into by the reference judgment was the concept of creamy layer. So creamy layer, they relied upon Jarnail Singh, where the Jarnail Singh judgment had held. Jarnail Singh was the one where N. Nagaraj was referred to larger bench and Justice Nariman's judgment of Jarnail Singh, partly saying that M. Nagaraj is not totally in consonance with the Indrasani principles. So in Jarnail Singh, they had held that creamy layer would be applicable to SC/ST. So that is another area which was touched upon in the reference judgment, though specifically, as we will see right now, the reference one wasn't that the questions were framed. The reference really was reconsideration of the E.V. Chinnaiah judgment. But creamy layer discussion did take place in the reference judgment. One specific point which probably also persuaded the 5 judges to refer to larger bench was in the meanwhile introduction of Article 342A. Let me just read that. So 341 was the presidential list for scheduled castes. 342 is presidential list for the scheduled tribes. 342A was inserted in 2018. It was for presidential list for the socially and educationally backward classes. So for SC/BCs, again a presidential list was created. So what Justice Arun Mishra notes is that if 341, 342 and 342 capital A is almost paramateria in nature, and for the purposes of OBCs you have sub-classification being permitted, why is it for SC and ST should not be permitted, though the president is making the same list and then the parliament can change, exclude or include. So that was another reason which prompted the 5 judges to refer this matter to a larger bench. And finally, what it says that we endorse the opinion of bench of 3 judges of E.V. Chinnaiah is required to be revisited by larger bench, more so in view of further development, that is 342 capital A insertion, amendment of the constitution which have taken place. So this was the foundation on which eventually the matter was referred to the larger bench of 7 judges. Now in the 7 judges judgment, there are 7 judgments, 6 judgments. The lead judgment is by Chief Justice Chandrachud and Justice Manoj Mishra. The second judgment is by Justice B.R. Gavai, who also deals with creamy layer, which Chief Justice Chandrachud does not deal with. Then there is a judgment by Justice Pankaj Mittal, who says that I concur with both the judges, the 2 judgments, including the creamy layer by Justice Gavai. But as I had indicated earlier, he spoke a bit about the Varna system. In fact, Justice Mittal also goes on to say that at some point of time we have to reconsider this entire concept of reservation, and that maybe there are other methods and means. He says that the requirement of supplement is absolutely necessary. He says reservation otherwise also is a good process, where at the end of it is at some point of time we might have to reconsider and see what could be other ways and means in terms of uplifting this class of the society. Then Justice Vikram Nath and Justice S.C. Sharma, they have written very short judgments, effectively concurring with both the judges and specifically concurring on the creamy layer issue. And then we have one dissenting opinion by Justice Bela Trivedi. So I'll go through each of these in some detail now. Now over here, apart from Punjab, the case from Haryana had also been tagged along. Haryana had also issued a notification for the purposes of sub-classification. So that also got tagged along with this matter. And the third matter was with respect to Tamil Nadu. They had also come up with the Act of 2009, sub-classifying some of the scheduled castes. That also got tagged along. So all these 3 matters were together, and that's how they had all got referred. In terms of issues which were framed by Chief Justice Chandrachud, one, of course, was the issue of sub-classification of the reserved class, whether it's permissible within the Articles 14, 15, 16. One very important, which remember Justice Sagri had also talked about, that the scheduled caste, whether they constitute a homogeneous group or a heterogeneous group. Because the basis of E.V. Chinnaiah was that it is a homogeneous group and therefore there cannot be further sub-classification or further sub-categorization. So that was another issue which was framed. Then it was about Article 341 and its interpretation, because the deeming fiction was what probably had troubled the bench in E.V. Chinnaiah, and they felt that because there is a deeming legal fiction created under Article 341, therefore it is all a single group and cannot be further subdivided. So that's another issue which was framed, and then talks about the limits and scope of subclassification, etc. Now, so far as the issue of subclassification is concerned, as a matter of jurisprudential principle, what the Chief Justice holds is that it is equally a facet of Article 14 and 16. He said that the way we classify between the general category and the SC and the ST and the OBCs, there could be situations on the basis of backwardness. It could be social backwardness, it could be educational backwardness. But similarly, within the classes, there could be a possibility that the backwardness and the forwardness within a certain class itself, or the SC or ST, is possible. And therefore, that will equally be a facet of Article 14 and Article 16, that we should we should create appropriate measures and means so that we are able to guarantee them that equality. And he said it should not be a mere formal equality, it needs to be a factual equality. So factual equality would mean really be able to collect the sufficient data, the empirical data and the ground realities, and then assess whether further subclassification is necessary for the purpose. So the concept of factual equality is something which was imported by Chief Justice Chandrachud to say that this is a facet of equality, subclassification is equally important. Now then he moved on to discussing Indira Sawhney judgment in quite detail, referred to Justice P.P. Jeevan Reddy and Justice Pandya's judgment. And what had troubled the E.V. Chinnaiah judgment, that Indira Sawhney excludes SC, ST in so many words, and therefore all the principles which have been applied for the purposes of OBC will not apply to SC, ST, including the subclassification. What the Chief Justice says is that if we go through the judgment more carefully, it is not that SC, ST is excluded for the purposes of application of the principles. Why it was separately noted is because it is anyway a backward class. That's something which the list under 341 and 342 is already declared to be a backward class. Indira Sawhney was primarily looking into other backward classes. And therefore from that context and from that point of view, the judges felt it necessary to clarify that SC, ST is something we are not concerned with at this point of time in this judgment. So keeping that in mind, Chief Justice Chandrachud, he finally held that Indira Sawhney observations does not really come in way insofar as applicability of the principle of subclassification is concerned with respect to SC, ST. That is something which is actually necessary. In fact, the principle of applicable to OBC would equally apply, because at the end of it, they are all part of the larger backward classes of citizens, which is reflected in Article 15.4. So, keeping that in mind, the principles of Indira Sawhney was made applicable. Then another issue which was looked into was Article 335. Now, 335, I'll just read it before I proceed. So 335 deals with the claims of the members of SC and ST shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of the union or of a state. So two parts. One is that the claims of SC, ST is required to be seen. The claims with respect to their involvement in public employment, their involvement in state machinery. But at the same time, that has to be then balanced with the requirement of efficiency in administration. Now, looking into 335, apparently one would feel that the moment you try to lower the marks or you try to load some kind of efficiency test, that would actually affect the efficiency of the administration. Now, this is an area which is now looked into by Chief Justice Chandrachud. He again applies the factual equality test. Now, you say if you go a bit deeper into the ground realities, if suppose somebody who has had some good education and he actually appears in an examination for public employment, then he probably will be able to ace that examination, as opposed to those who never had the occasion of having good education, or even what he even calls as a cultural capital. Cultural capital is something that the family in which you are born, the surroundings in which you are living, the kind of advice you get from the parents or from your relatives or even from your near and dear ones, the kind of approach you see towards the life and the values you get, those are all part of cultural capital. So there are many of these differences which are natural when a person is born in a certain family as having sufficient means, as opposed to a family where those means are not there, leading to backwardness. So that is where he said that the efficiency really has to be tested from that principle, and therefore 335 has to read from that point of view. And even if you are lowering certain marks, etc., it does not really attract the menace of lowering the efficiency in the administration, and the balance in 335 therefore be maintained if you have that kind of a reservation. So 335 is what he dealt with in that manner. Now Article 241, which was really one of the deeming legal fiction, that probably was the ghost in the room which was troubling everyone. Now the normal principles of deeming legal fiction, as I just indicated, is that the moment something is deemed to be in a certain way, a legal fiction is created, then it has to be taken as if that is the real situation, though it might not be. Now the language used even in Article 366, the definition of scheduled caste, or in 241, the language uses that it will now be deemed to be scheduled caste. However, Chief Justice Chandrachud looked into the provisions more carefully and he said there is another meaning to the word deemed, which is regarded as. So it is not that a legal fiction is created for the purposes of the constitution. They are already backward, but because once the president, upon consultation with the governor, has come up with a list, these castes or races or groups have to be regarded or treated as scheduled castes. So there is no question of a deeming or legal fiction that for that purposes they are all to be a single unit. So why the entire legal fiction issue was being created was because it's a legal fiction, it is all a single unit, a homogeneous unit, that which cannot be divided, that it will be presumed that everyone has got similar characteristics. He said that that's the wrong reading. This is not a legal fiction in the way normal one would recite. It is really to be taken as regarded as. And the second, even if it is taken as a legal fiction, it is legal fiction only for the purposes of identification of that group, not for the purposes of reservation under 15(4) for public employment. He said that is a different thing altogether. For the purposes of identifying, you said these are now deemed to be scheduled castes. Ahead, what would be the benefits or the measures or the means to be taken for the purposes of uplifting that particular group is something totally different. So that's how these two particular tests which Chief Justice Chandrachud looks at and says Article 241 can never be an impediment in the manner in which E.V. Chinnaiah believes it is. So that was Article 241 discussion which Chief Justice Chandrachud looks into. To actually look into 241 list, he also then relies upon reports. Now that was a part of the empirical data. There were pre-independence reports, the census report of 31 and a whole bunch of reports he looks into, to show that even at that point of time, even Dr. Ambedkar had given quite a bit of input in those reports, that there were clearly differences between castes within the scheduled caste tribes, or the depressed classes as they used to say, or after 1935 the scheduled caste. So those differences were apparent in terms of how a certain caste would treat even a lower caste in a certain manner, that the upliftment was not possible. And therefore, even pre-independence, there are reports to show that they were never a homogeneous group. They had always been a heterogeneous group. For the purposes of identification under Article 241, they were all brought in of scheduled caste, so that we know the benefit needs to be gone to them. But within that class itself, that caste, scheduled caste list, one can divide if the need so arises, the factual equality. So there were also post-independence studies of Gujarat, of Tamil Nadu, which too looked into this kind of heterogeneous society. So that is where he looked, and he said that at the end of the day, number one, Article 341 list is not about a homogeneous group, it is heterogeneous group. The deeming legal fiction does not come in the way of subclassification, and subclassification itself is a facet of Article 14 and Article 16. Next, he moves on with the criteria for subclassification and how it has to be looked into. So he said that two tests clearly: social backwardness has to be seen, and secondly, inadequacy of effective representation in public services. Both are really coming up from Article 15(4) itself. The social backwardness is clearly in terms of the fact that they are part of this list itself shows they're socially backward. That's what Indra Sawhney had also said. Secondly, in terms of representation, he said there should be an effective representation, and that also is based upon empirical data. The next point he looks into is the models. That what possibly is the models which has to be adopted for the purposes of subclassification and reservation. So the two models Chief Justice Chandrachud looks into. One model he says is the preference model and other is the exclusive model. Now the preference model is something like what he calls as the first bite. So that you can say that X and Y would have first preference over those seats, failing which the remaining would be able to opt for those seats. So that's the preference model. Other he says is the exclusive model where you exclusively look into a certain percentage of seats and you offer it to that particular X or Y caste only in the subclassification. So if there are suppose A, B, C, D group, A group probably would get 5%, B group would get 2%. So that way, so in terms of groups, the benefit of this would be that in case those seats are not filled up, they are then carried forward in the next. So these are two models he finally looked into, and after looking into all these principles, finally Chief Justice Chandrachud held that the principles laid down in E.V. Chinnaiah is the incorrect exposition of law and it's an incorrect interpretation of the constitutional provisions and therefore finally over. So that is the judgment of Chief Justice Chandrachud. The next judgment, which was substantially dealt with the entire issue, was given by Justice Gavai. Justice Gavai also looked into all the reports, pre-independence reports and post-independence reports, and to hold that this is not a homogeneous group, it is a heterogeneous group. He also extensively referred to Dr. B.R. Ambedkar's deliberations in the assembly debates, where the discussions about why backward class operatives, the word backward has to be inserted, and why is it that there is a requirement of the presidential list. So all those were also extensively dealt with by Justice Gavai. There was another judgment of N.M. Thomas, which was relied earlier by the judgment in E.V. Chinnaiah. And Justice Gavai again looked into it and said that so far as that is concerned, again Supreme Court has never held that it is a homogeneous group. And once there is a 341 list which comes in, then the list has to be treated as people with backward, but definitely not as a homogeneous or a single entity or a single group where there cannot be further subclassification. And Justice Gavai too agreed with Chief Justice Chandrachud, and he said that so far as Indira Sawhney judgment is concerned, Supreme Court had only said that so far as SC/ST, they are already treated to be backward classes because they were a part of the Article 341 list. Therefore, there is no reason to look into that group. It was more about the OBC group it was looked at. There was a very interesting report of A.N. Sinha Institute of Social Studies in Patna that was referred to by Justice Krishna here earlier, which is again referred to by Justice Gavai here. And they had looked into the dual societies among Harijans. That they are Harijans who are slightly treat themselves of a higher Harijan as opposed to lower Harijans, and therefore the interstate discrimination between Harijans. So that was an interesting factual report which was looked into and considered by Justice Gavai in his opinion to ultimately lead to the conclusions which we'll be looking into. And then he finally says that there is a clear error in the E.V. Chinnaiah judgment. It presumes that the Article 341 list deals with reservations in itself. He says it does not deal with reservation, it deals with merely identification, identifying the beneficiaries of the reservation. So once it looks into the identification, the next step of reservation is something which then goes within the cradle, within the fold of the state legislature, within 15.4, and therefore the state legislatures can then pick up on the basis of empirical data as to what extent reservation has to be given to whom. So it clearly holds that E.V. Chinnaiah is an error over there. So far Andhra Pradesh is concerned, specifically empirical data was put before the court, and they found that 4 out of 60 scheduled castes, only 4 out of 60 scheduled castes in the president list were actually benefited of the reservation till date. So 54 scheduled castes were never benefited really in its true sense. So therefore the purpose of reservation, the purpose of having this kind of an affirmative action was found to be completely destroyed, because giving preference to certain castes within the same list and only being awarded treating them as a common group, a homogeneous group. So this was a very important data which came on board before the Supreme Court. And finally Supreme Court Justice Gavai, he said that so far as preferential treatment is concerned, that would not amount to tinkering of the list in Article 341, because that is of course only within the realm of the Parliament. But the states are not tinkering, the list remains the same, they actually pick up from the list, and if they feel that there are certain castes which actually requires a preferential treatment slightly above the others, then that should be permitted. Of course, they say the state have to identify in terms of actual empirical data that those certain scheduled castes require more, shall I say, protection than the others are required. And then finally it held that subclassification is permissible, but only when the subclass as also the larger class is given the reservation. That's something which Justice Gavai specifically towards the end in his conclusion said, that it is not that you merely reserve only for subclass forgetting the larger class. You see, the larger class has to be reserved. Within that you can create a subclass for the purposes of giving special reservations, special measures to them on the basis of this empirical data. Now, so far as Justice Vikram Nath is concerned, he concurred with both the judgments, and Justice Pankaj Mittal, as I said, he looked more to the Varna system and his own thought process. And Justice Satish Chandra Sharma also, in a very short judgment, he says he concurred with both the judgments and specifically with creamy layer. So these are the 6 judgments of the 6 honorable judges, which is the majority judgment, and which finally has overruled the Chinnaiah judgment. It also has held that Article 341 list does not contain a homogeneous group, which is a heterogeneous group, and that subclassification is permissible within the scheduled caste itself, because that is what Indra Sawhney had held insofar as the OBCs is concerned. Now, so far as Justice Bela M. Trivedi is concerned, I'll just touch upon the basis on which she has given a dissenting judgment. One, she looked into the reference itself, and the reference she saw that the first reference to 5 judges was not a reasoned reference. So that order is a very short one. It says, after hearing the parties, we believe it should be referred to a larger bench of 5 judges. And then the 5 judges, of course, Justice Arun Mishra, as we have just discussed, is a detailed one. But Justice Trivedi believed that the first reference itself was unreasoned, and thereafter even this larger bench reference was uncalled for. So that's the first point she touches upon. She says this entire larger bench reference was really uncalled for, everything was really covered well, and Chinnaiah judgment has got nothing to do wrong. Second, she says that Article 341 list is the final list, and the fact that it is a deeming legal fiction, it gives a special status to the SCs for the purposes of the measures to be taken under the Constitution, and therefore that cannot be touched in any manner by the state governments, and even sub-classification is not permitted. In the same context as Chinnaiah holds, she again upholds that and says that this is actually a homogeneous group because of the legal fiction which is created. She says we have to go by the literal meaning of the words used in the Constitution, and the word it says it is deemed to be a scheduled caste, and the moment it says it is deemed, therefore that's how it has to be taken with. So finally it holds that, she holds that the Chinnaiah judgment is correct, and sub-classification is impermissible insofar as SCs is concerned. So that is Justice Bela and Trivedi in terms of this one. So this is where the larger picture comes up, the entire journey of how this entire sub-classification process has gone. Just as a closing remark, and this is a report which I found, I didn't really see in any of the judgments being referred to. So in 2004, in Rajya Sabha, a bill was introduced that was for SC, ST, OBC reservation of bill. That bill was referred to the parliamentary committee. The parliamentary committee called upon the state governments to respond, and they also called upon the experts to respond. It is interesting that in there they actually found specifically for Punjab that the 2 castes which deals with the impugned act over here, the Punjab had said that these 2 acts almost constitute 60% of our population, and yet they barely have a representation in public employment. They are a part of the SC list, but they barely have a representation, so probably something like a sub-classification is required for the purposes of uplifting them. Similar kind of an issue also came about by Andhra Pradesh, which again was one of the matters. The Chinnaiah was Andhra Pradesh. So after looking into all that, the parliamentary committee report suggested that probably there is a requirement of some kind of amendment in the constitution. But they agreed that sub-classification in the SC list should be permitted, of course whether permissible or not, and the interpretation was left to the court. And this report came barely 1 month after the Chinnaiah judgment. There is no reference, of course, of the Chinnaiah judgment, but the fact that the parliamentary committee report also believed in the same thought process as today the 7 judges shows that in terms of reservation policy, at the end of the day, the executive and the judiciary has been going hand in hand. As I have shown you the entire journey, in areas wherever there has been some kind of an amendment for the purposes of taking the equality clause forward and to uplift the backward classes, the Supreme Court has always come hand in hand and to interpret the Constitution as a living organ in a manner so as to uplift the equality clause. So this report also reflects the same thought, what is reflected by the Supreme Court in the 7 judges. Right. Thank you so much. I'm truly grateful for this opportunity. It was a pleasure as always. Thank you.
Thank you, Bharuka. Very nicely explained everything. It's a constitution bench, different judges, how they explain the judgment and the concurrent and Dissent and other things. When nearly 500, more than 500 pages what judgments are. But it's a burning issue. We have dealt it very simplified, honestly. Oversimplified, and we touched them in the Mandal Commission and others also. Excellent, extremely we are very. In a short notice, he gone through. आप जरूर कुछ बनोगे और आगे. गीतांजलि in your interest.
Good afternoon, everyone. Absolute pleasure for me to express gratitude for today's session of the Friday group. To begin with, deepest gratitude towards Devashish Bharuka sir for being magnanimous enough to lend us a slice of his priceless insights about the recent Constitution Bench judgment of State of Punjab versus Devendra Singh, in which the sub-classification among the SCs about reservation has been talked about. Sir, you've been kind enough. In less than an hour, you took us through the genesis, impact and interpretation of cases right from Champakam Dorai Rajan to M. Nagaraj to S. Vinod Kumar, and how the concept of deeming legal fiction hit E.V. Chinnaiah, which has now been remedied by the latest judgment. Sir, very heartfelt thanks for taking out time and enlightening us.
Always a pleasure.
As always, can't do without thanking the man with the plan, Sr.Adv Rao sir, who has upheld this flame of knowledge called the Friday Group for almost a decade now, and going strong and how. I would be failing in my duties if I didn't thank all the attendees present here. It's all of you that make us go on. Thank you so much.
Thank you. Can you pass on the book, attendance register book?